Islamic law had attained considerable maturity by the end of the 4th century of the Hijra, which corresponds roughly to the year 1000 of the Gregorian calendar. By this time, most of the legal texts of the Quran and the Sunnah had been interpreted to derive laws from them. A need was felt for a methodology that would facilitate the development of new laws that were not expressly stated in the texts, nor could they be derived through implication and strict analogy. This methodology had to ensure that the intention of the lawgiver and the norms of the Islamic legal system were observed in the new laws developed. Drawing on 4 centuries of work, the jurists came up with 5 ultimate principles, supported by a large number of other legal principles, with reference to which all new laws were to be developed. The 5 principles are: first, deen, or the system established by the religion of Islam, has to be preserved and protected. Second, nafs, or life, has to be preserved and protected. Third, nasl, or progeny, or the family system, has to be preserved and protected. Fourth, aql, or intellect or reason, has to be preserved and protected. And fifth, maal, or property and wealth, have to be preserved and protected. The 2 words preserved and protected indicate a similar meaning, but the jurists have indicated to us that these reflect 2 different faces of these principles. By preserved, we mean to affirm, to develop, and to make the system contained in the principle to grow to its full maturity and potential. By protection, we mean the defense of what has been developed. This is done by defending against invasions and by providing penalties and remedies for infringements and violations. As compared to this, the term Shari'ah means the policy of the Shari'ah. The policy continues to be based on justice as long as the government upholds the Shari'ah. If it does not uphold it, the policy becomes unjust or zalima. The policy of the Shari'ah is of 2 types. The first deals with the preservation aspect of the 5 principles mentioned, while the second deals with the protection aspect of these 5 principles. The policy dealing with the preservation aspect we will call the social policy of the Shari'ah. This policy identifies the goals to be attained by the system or the targets to be achieved by the ruler or government. The duties of the government are contained in this policy. This public policy is relevant to the legislature and the executive, and they are duty-bound to uphold and implement this policy. Economists should focus on this aspect, while the legislators should convert what is deemed immediate into law or legislation. The executive must base its proposals and policies on this aspect and seek to implement them as far as possible. The policy dealing with a protection aspect we will call the legal policy of the Shari'ah. It consists of all the principles, presumptions, whether legislative or other, rules and targets meant for the judicial system. This is the domain of the jurist, the judge, and the lawyer. They must always uphold these policies during adjudications and elaboration. The legal policy of the common law has taken centuries to develop through the effort of the judges and lawyers. Islamic law is no different. It took the jurists centuries to refine these policies by going over the texts in minute detail and by issuing rulings spread over centuries. The difference between Islamic law and common law is that the social and legal policies of the Shari'ah were refined and fully developed long before common law was even born. And who knows, the common law may even have borrowed much from Islamic law. As some say, the word ascesis of the common law is nothing more than a translation of the word siyasa. Perhaps the most important feature of the purposes of law is its dual thrust. Al-Ghazali discusses this dual nature in detail. This point has also been emphasized by the Spanish jurist al-Shatibi. He says about the first aspect of preservation that this is what affirms its elements and establishes its foundations. The second aspect is about what repels actual or expected disharmony. The focus of later jurists, and hence that of modern scholars, has been on the aspect of protection alone. Each purpose, however, has a positive or aggressive aspect and a negative or defensive aspect. These are what we now call the social policy and the legal policy of the Shari'ah. From the positive aspect, or the aspect of social policy, the interest is secured by establishing what is required by the Shari'ah through each of its purposes. Thus, the interest of religion is secured by the creation of conditions that facilitate worship and establish the other essential pillars of Islam. The interest of life is secured by creating conditions for the existence of life. The interest of progeny is supported by facilitating and establishing family life. The interest of intellect is secured by promoting the means for the growth of the intellect. The interest of wealth is secured by creating proper conditions for the growth of wealth. From the defensive or the protective aspect, which we now call the legal policy, interests are secured by preventing the destruction or corruption of the positive aspect. Thus, jihad is prescribed for defending deen, while prayer, fasting, pilgrimage, and zakat help establish it. It is the duty of the ruler to ensure proper conditions for both, while it is binding upon each subject to fulfill these duties, individually and collectively. Life is preserved through the provision of sustenance and the maintenance of good health, while it is protected or defended through the provision of penalties for those who destroy life without legal justification. Nasl is promoted through the maintenance of healthy family life and the institution of marriage, while penalties are provided for those who would corrupt it and destroy its values. The preservation of aql is achieved through the provision of education and healthy conditions for its growth, while penalties are provided for the consumption of substances that destroy the intellect. Preservation of wealth is achieved by encouraging its growth, while theft or misappropriation of wealth is punished through penalties. It is to be noted that jurists have considered each separate purpose as a policy. They refer to them collectively as siyasat or policies. Work needs to be done to work out the details of each policy.